Right, a very short court session this evening. We didn't anticipate that it will take that short to deliver the rulings. Looking at the applications that were made yesterday, we actually expected that as practice it might take a little longer, but I think the judges woke up well. They did their work in time, and they've spent most of the time just reading the conclusion of the rulings instead of delving into the whole works that perhaps they have spent most of the day. We know most of the submissions, especially for the amicus and for the interested parties, were done in writing. So probably they spent more time reading and summarizing what they were supposed to do, and in a record, about 50 minutes, I think it's been done. They began a few minutes to 8, and by exactly 8:30, they were done, paving way for the trial tomorrow. However, one issue has not been settled, the issue of access to information, and that will be settled tomorrow. So the pictures on your screen is at the conclusion of the ruling that have been read this evening, with the 7 judges, concluded there with the senior most, who is the Chief Justice. But at the Supreme Court, he's considered as a judge, just equal to the other judges, although he's given a higher status, I think. Now, I want to introduce my panel right now to help us talk about what has happened this evening. And I start with Kakai, with the senior most. All right. Moses Kurgat joins me once again. Now, where do I go? You confused me. Then Kakai Kissinger. Yes. Then I come to George Kithi, and lastly, if we were to talk about seniority, this guy was below me in class. So and my name is Ken Mijungu. Thank you very much, gentlemen, for remaining with us this evening. Let's talk about this and get it out of the way. Let's start with what they haven't done, the access to information. The application was very long. Probably that is the reason why they have taken a little longer to get into it. Let me start with the senior most, the application on access to information by the petitioner.
Yes, as you've just put it, I think it is heavy. It is heavy, and that is why you saw the Chief Justice saying this application cannot be finalized today and that it will be done tomorrow. So the ruling is pending, awaiting that important decision tomorrow. We wish to see what happens, but as you could see from the nature of the application, it was asking for major orders and major issues to be undertaken within the servers of IBC. Okay. And this is a matter that has great significance. It's a matter of great significance, and it has a great impact on the prosecution of the petition, finally, when it starts.
All right, let me go to George. George, just take us through this application, and we'll all add in to this application. What does it contain, the application on access of information by the petitioner?
First, you will notice that has been pended. The ruling on it has been pended, obviously because the content is very demanding, because you need to reason out more. The others were easy because you realized even the reading of the rulings on the rest, we could easily move into the introduction and the conclusion as to whether it's dismissed or not.
A minute.
Yes, and that was easier. But for this, you need to digest several issues, balance the timelines against which the investigation was going to be done, how much access is going to be given without prejudicing the proprietary rights in it, as is given on by IBC, against also whether or not that is the right in law of access to information, or right, also balancing the fact that they are looking for evidence to add to what they already have, which again may be a right, or maybe a right that they ought to have obtained before filing the case. Okay. Is it a duty of the court to try and obtain evidence for them, or is it a right that cannot be removed from a person, an entitlement to a person, notwithstanding that the person is already in court? Some of the issues that they need to look at also, and I think is what they're considering, is that was it something that should have been done like was done in the last election? Because what happened in the last election is there are preliminary applications, in fact a plethora of applications to obtain certain documents in the High Court, and these were allowed, some were not allowed. And therefore that is the environment that they're looking at. Already there's an element of jurisprudence in the past election that they also need to consider, and also consider whether they're departing away from it or still holding the same. But again, you realize that what has been requested is twofold. Access to the servers, so that then they can extract information. That information then shall be transmitted to court for purposes of joining the rest of the evidence, and therefore complementing and supplementing the case for NASA. The other issue also is on the issue of Form 34s. Remember, there was an argument by Muita yesterday where he said that they are available and therefore can be produced. Thus, an adjournment was prayed by Fred Ngatia. He was given 10 minutes. In his rejoinder, he said that whereas they think they are on the same platform with the first and second respondent, they are not agreeing to that application being granted, because otherwise they should have had their own forms against which they can make the comparison. And also timelines were not available. There was Issa also who complained that certain timelines were not available to
I'm coming
allow
back to you, George, because that application was made by James Orengo and is currently speaking to the media. Let's just listen in and then we'll get back to us.
We're on our way for the hearing of the petition.
Yeah.
So we're quite comfortable.
Finally, going forward, do you think as a country we need to look at these timelines again? Because there's a lot of pressure not only on yourselves as parties, but also on the judges.
I think it is necessary, and I think from the position of the judiciary itself, they gave their views during the process of amending the Elections Act towards the end of last year and this year, and they did recommend that we need to extend the period. But because it was a constitutional amendment, there were problems about making those amendments.
All right.
Yeah.
Finally, what do you tell your supporters? I know I said finally, but what do you tell your
No,
supporters?
I'm no supporter. I've just got a client,
Yes.
or two clients who are petitioners. And that is the job I have to do, together with my colleagues.
All right.
Thank you. Thank you.
All right, James Orengo speaking right there to the media after the court session. He was the applicant, and this is what we were talking about, the access of information. James Orengo was the applicant, and they're waiting for that ruling tomorrow. George, just conclude by talking to us. Could have Issa Mansour for the respondent, I think the IBC chair, could he have thrown the court off by making the submissions that access to this could also mean that they need to back up their servers before they do it? So probably, could you talk about that also?
Yes,
briefly?
before I get there, Orengo's complaining to me that he is not the applicant. He is acting for the applicant.
Yes,
yes,
that
yes,
was obvious, yes.
But yes, one of the issues that the arrangement for the servers is that it doesn't just contain the information being sought. It contains some other information because the build-up has been for many years. Okay. So then, if that is allowed, there's other information which, again, probably will be tampered with. There are certain rights that are embedded in that server which probably will be interfered with. The Chief Justice asked him whether, although he's not an ICT expert, whether then there are certain tools that can be used to access and not to access other information. And probably that then is the consideration. The Balancing Act is very delicate.
Yes.
It's a matter of public importance, and the court must get it right from inception.
All right. But on this, some of the people who apply to be enjoined as interested parties, Kakai, and then I'll come to Moses, it's the ICT Association of Kenya. They have been denied access. They have been told you cannot be part. You are adding nothing new to this.
Yes, and that of course got me by a little bit of surprise, although they didn't tell in terms of what were the key reasons why they were not being allowed, because it seems to have been that it will have been the best institution to give opinion on that issue. But when you see a court not deciding on an issue which was litigated yesterday, it just shows two things. One, that there's a division within them, within the judges. There's a very huge division within the judges of what direction do we take. Remember, this is information which is contained in the Constitution and it's public information, and everybody is accessible to this information and are entitled to this information. The other thing which clearly shows is that probably they are seeking for varied opinions. Nothing stops the judges to seek for opinion in privacy. Nothing at all. As long as they can seek for an advice and rely on that advice to make the judgment in terms of which is the way to go.
Right.
But I can assure you that by tomorrow, they will have somehow settled on the direction.
All right. Moses.
Thank you. I think, I don't know whether there's any division among the judges. I think it's a supposition by my colleague. But it is something that we could, of course, talk about. My view is that they want to give a reasoned judgment, a reasoned ruling and findings, so that when they make the decision, then it is sound in law, it is going to be enforceable. Because if it is not possible to enforce it, then it becomes difficult to be useful.
All right. And perhaps this is also the single reason why the ruling was postponed from 3 p.m. today or 2 p.m. to 7.
Mijungu, I think that will be one of the reasons, because if you look at...
Just lift your mic a little.
If you look at what how the rulings were delivered, you'll notice that they were delivered on the basis of consensus. A judge was actually reading a ruling which was actually arrived at through consensus by all of them. It therefore tells us that even this particular ruling that has been postponed, they may actually be trying to arrive at a decision based on consensus. But you remember that this particular...
So you are agreeing with Kakai?
No, I'm not even agreeing with him, because I'm saying that you will notice that this particular application has several limbs, as my learned senior Kithi has already indicated. So it's not a straightforward application of a yes or a no. Even if you say it is a yes, there are parameters that must be set. There are things that they may have to gauge. And maybe that is where learned senior is saying, and even Kakai, that they may need to consult further, so that whatever decision they make would actually cater for the interests and the concerns that IEBC had already raised yesterday. So we will have a decision, but that decision must actually be one that will not cause a lot of hue and cry from the parties themselves.
All right. I want to talk about one issue, then we'll take a break. We'll be coming back at the top of the hour. The persons who have been denied, and I'll begin with Baraza, who has been denied. He was not adding anything new. And Isaac Alucher, as an interested party, they say that he was going to entirely change this case, because even if you look at how he had arranged the respondents in this case, we're going to begin with Uhuru Kenyatta as the first respondent and probably end with the chairman as the last respondent. Let me start with you just a minute, then we have to take a break on that. Why was Baraza dismissed and why was Alucher dismissed?
Baraza, that dismissal was a bit harsh, but I think it was warranted. He was adding no value, meaning he was a busybody. In other words, what the words you should have said is a busybody. On the other, and this is probably a lesson to everyone, if you want to join a case, that's not your cooking.
Yes.
It's not your food. It's not your party. So when you go there, you must go there and not try to rearrange things.
Okay.
You'd not introduce new matters. You'd not introduce new parties. You must conform to what they've already brought. Meaning, the petitioners are so-and-so, the respondents are so-and-so. Don't bring someone else. He was trying to bring William Ruto.
Then you run into the danger of being dismissed, because the question will now be, what new are you adding that has already not been canvassed?
That's the point.
Yes.
And in fact, by the way, if you and you have sued each other and I think I'm interested, I don't introduce him as a third person. I must conform to the two of you. So if I think the way I come, he must be introduced, it means it's a different case. So the alternative to it or remedy to it is to file your own case and be heard separately,
and
but
your
not
own
within
case,
this case.
And in your own case, and in this case, it's dismissed.
And you
right?
must deposit that 1 million, which is trying to escape anyway.
Oh, okay.
Exactly. I think, let me just add something a little there. Mr. Oluchiri is a perennial litigant in this court. In
So
2013. Yes, I know.
He was even in the ballot case.
Yes, exactly. Both of them have been perennial litigants in the courts, and especially for petitions. In 2013, Oluchiri was there fighting to be included, and he was also kicked out. Now, what I think he should have done, if he truly looks like the grounds he had, could have been very useful if he filed his own petition.
Okay.
Then it is consolidated with this one.
Okay.
Then it would have made a lot of sense. You remember, Africa did that with Raila Odinga.
Okay.
They were all consolidated
But
into
Ken,
one.
more so,
Yes.
you understand that when you listen to the judgment or the ruling that came out, the court is more concerned about the actual parties in the suit, and they want to give them as much time as possible. That's why you are seeing that the busybodies that we're talking about have been removed, and even when it comes to amicus, it's been restricted because it's now about the parties to prove their case. And so we limit a lot of time. And are learning more from what happened in 2013, where they left amicus to run the whole show and touch on everything and nothing. So now it's being more limited.
All right. We'll talk about that in the next hour, obviously, because the AG has been admitted, but there are limits. LSK admitted, but there are limits. So is Michael Wainaina and Kurgat Okatch. But summarize this for us in a minute. We have to take a break.
My take
in terms of the people who have been denied.
Yes, my take is that the denial is actually warranted because you remember all of us are saying there is no time, and it's common ground that there is no time. But more importantly, there are rules of admission. You must actually demonstrate why you are coming in. So if the ICT group has actually not been granted, it tells you that the bar was so high. And I said it yesterday that they will actually adopt a restrictive approach, which will be applied across the board.
All right, we are taking a short break right here from the Supreme Court of Kenya. We're going to have the news at the top of the hour, but the panel is staying here with me. We still have a lot of issues to talk about, including the time allocations. Yesterday we left at 6 hours, 2 hours, now it's been reduced. And more importantly, my panel will have to respond in this. The criteria the judges used in allocating the first and second respondent an hour and a half each, and allocating the third one 3 hours. Obviously, it's something that is out there, and probably we'll also talk about how possible is it to submit on behalf of IBC chair and IBC at the same time. And obviously, we'll also talk about the value that each person who's been admitted as an interested party or alternatively as an amicus to this court, the value they bring to this case. That coming up in about 10-15 minutes, but the news will be there at the top of the hour also. So stay with the panel. We'll be right back. Decision 2017 continues right here at the Supreme Court of Kenya. And my panel, just introducing them once again: Kakai Kissinger, Duncan Okatch, Moses Kurgat, and George Kithi joining me once again. And we want to really summarize this up for you because tomorrow we are up and early back here to talk about this. So one of the things that has happened in court this evening in that ruling is that the AG has been admitted as a friend of the court. So is the Law Society of Kenya. However, their role in these proceedings have been limited. And the AG, gentlemen, will be talking about the precedents in the IBC versus Maina, Curiae, and others. I'll start with you, Kakai. Why has the AG been admitted? Because again, they're going back to 2013 and looking at the AG when he was the friend of the court, and almost they took over the whole session of the court, and it's almost as if they directed the proceedings then. So why are their role limited? Is it to cure that first?
Yes, one of the things is to limit the role of the amicus, friends of the court, is because of the time frames that are allowed. You know, the 14 days time frame did not fall from the sky. 14 days timelines are the Kenyans themselves who wanted it. If you recall the Guy Commission, the Guy Constitutional Review Commission, they'd actually proposed for 7 days. When the Constitution was mutating to Kilifi, then finally Boma's draft, it increased it to 14 days. So they are stuck with 14 days. However, when you look at the past 2013 presidential petition, they were really restricted in terms of the time frames. So one of the issues here is to try and remedy the mistakes of 2013 and limit issues in terms of time frame and just give the amicus specific roles to perform in terms of the functions so that you give more time to other parties, key parties.
All right. Talk to us about this case, the IBC versus Maina Curiae. What was involved in this case? Because that is the substance that is bringing to this case.
Basically, that is the mainstay in terms of the NASA petition, because no one is challenging, they're not challenging the aspect of voting itself. They're challenging the aspect of transmission, which actually entails transmission itself. And it is always said that democracy is not just the voting part of it, but more so the counting part of it. But with the influx of technology, how it is transmitted was guided by the Maina Curiae decision in the High Court. The appeal itself now can actually canvass and cement that particular position, such that if IEBC will not have complied with that particular provision and jurisprudence, then the petition might sail through. If they didn't, if they actually complied, then the petition may actually lose its grounds. And that is what the AG is supposed to come and inform the court in terms of his interpretation.
But Wakili, will that mean that if he stands on a point, he will not be allowed to comment about it? If there's any other thing going on in court and the AG wants to make a contribution, will...
No, he can only make a contribution on the issue that he has been restricted to.
Only?
Only that one, because what they are doing is that, as Kissinger said, in 2013, the Attorney General seemed to have taken over the petition and prosecuted it on behalf of the respondents. And the criticism that has followed it over time is what is informing the court's decision this time around.
Okay.
Of course, the issue of technology law, which is actually anchored on Section 38 of the Elections Act, and of course on Article 81 and 86 of the Constitution, is that technology has been now brought up. It is said that technology now is a tool that lifts the boat. It is a tool that is now lifting everything for us in terms of how we execute our electoral practices, how we execute our voting. And then we look at, the AG will then be able to assist the court to understand the meaning of technology law, the meaning on the transmission, how it is supposed to be done, and how IBC could have done it. So it's actually a very significant role that the AG has been given.
It's not
a small thing.
Yes.
It is something that is going to assist the court to reach a fair conclusion or a reasonable conclusion.
George?
Don't forget one thing. The process of legislation in this country largely is the drafting of the law before it gets as a bill to Parliament. They then a lot of information informing every paragraph of a law that is made out, and that comes from the Attorney General. The rationale behind each legislation, therefore, can easily be explained by the Attorney General in court. Where are we coming from? What is it that we were targeting? For instance, if you make law and you need to cure a certain mischief that happened, then you apply the mischief rule. There's something called the golden rule. There are many other rules that you apply in terms of legislative interpretation, legislative drafting, and so on and so forth. When you do that, therefore, it then informs the court the background of each sentence, of each text in the legislative piece. And therefore, when you look at Section 38 and all these other sections of law, in terms of ICT, in terms of the other narrative, in the circumstance of the election and the dispute, it means then you need to look at the background. Why did Kenyans put this type of legislation? Is there a background to it? That then informs the court to have a general outlay of how to apply the law. He, however, is restricted to the extent that he can't touch on facts, he can't touch on tallying, he can't touch on Form 34, he can't touch on this and
anything
that.
Else.
He will only be restricted to the issues which are fundamental. By the way, on that alone, even 20 minutes are very few. Probably what he should do is file his own submission, because I do know 20 minutes is what probably the introduction on that part
will be needed,
by itself. Yes.
It's a case that went all the way to the Court of Appeal. So definitely, let's talk about LSK also, and I'll start with you once again, Kakai. LSK has also been admitted, but their role is also limited. What is their role?
Yes,
in this
LSK
case now?
has been admitted, and I'm glad that they were admitted. I think when you look at the LSK Act, they're leading in terms of issues that affect the practice of law in this country. So it's good that they were admitted. However, when you look at the restriction, LSK is only to deal with Section 83 of the Elections Act. And when you look at Section 83 of the Elections Act, it's dealing with non-compliance of law, whether if we do not comply with law, that effect of non-compliance of law can lead to invalidating an election. So those are some of the key things. So they need, therefore, to come up with very clear jurisprudence on that section, come up with very clear case law around that issue, and completely direct the court the effect of Section 83 of the Elections Act. That is very critical for them.
Yes, and that is essentially what we were speaking about yesterday, because we were talking about what will be used. What will be the threshold? Will it be on probable value of the case? Will it be beyond reasonable doubt? Or it will be based in law and the Constitution? That is what we were speaking about yesterday.
Exactly, Ken, and I'm glad the court has actually reduced it to that, because we said that the threshold in these election petitions is somewhere in between. It's not on beyond reasonable doubt scale, neither is it below probability. However, you will notice that there are two limbs that the elections, in terms of threshold. One is that there is the qualitative test and there is the quantitative test. That is Article 81 and Article 86. And actually, the court has given LSK the mandate to canvass that particular aspect, but also coupled with Section 82 of the 83 of the Elections Act, which clearly tells us that, and it's a question that came up in the previous petition 2013, and people have castigated the Supreme Court ruling, saying that they misapplied that. Because the issue is, we imported it from Britain. Britain says, and that means you must not only demonstrate that the elections were not in compliance with the law, but you must also demonstrate on this other end that it affected your results to a point that you could not win. But you see, when we brought it in Kenya, and the drafters of that particular legislation actually decided to use or, that means you can actually prove one and not prove the other, but still invalidate that election. That's a very clear point and important point, so that it is settled once and for all.
All right. Was this in the application by LSK, or the court chose for them what to do?
No, you know what happened? When they made the application to be joined as amicus curiae, as a friend of the court, they submitted an application, an amicus brief, which we don't have the benefit of it. We don't have. The court did not discuss it at length. But what they did was to tell us that they have agreed with the Law Society's position. My view is this, that Law Society, as a statutory body that is in charge of the practice of law in this country, must help the court to develop jurisprudence, to develop and allow the court to now give us direction. Because in 2013, the court failed to do that. They didn't have the opportunity. This time around, they have the opportunity, and it will cool down the temperatures. What is going to happen is that the Law Society will be able to guide the court on the legal impact of the sections that they've been restricted. That is Section 83, actually. They may not even deal with the issue of the technology law that the AG has been given.
At all.
Yes.
Right. All right, and finally, as you comment on that, I wanted to ask you also, their role is also limited and restricted to Section 83.
Yes.
Period.
A very interesting issue emerging, probably to our viewers. The derivative effect of that ruling, LSK has members who are fighting in court, fighting in a sense from both sides. Yet LSK has been admitted on a certain point and is supposed to be neutral because it's an amicus. How is that possible? And I think that's a simple. When you are appearing for either side, you are under instruction. When again you appear for LSK, you are under instruction to restrict yourself to certain issues. More importantly, that you've been directed by the court. So that the membership of LSK is not the same representation that LSK is going to appear before the court as amicus. Yeah. But another issue that's also emerging is this. The historical value of LSK cannot be underscored or neither gainsaid. LSK has at the forefront of championing reforms in this country. That coupled with the fact that they have a statutory mandate to do certain things is why they've been allowed. But more importantly, what the court has an advantage this time round is something called the finesse of law. You see, if you tell me to research on a certain section alone, then I'm more expansive, I'm more detailed. If you tell me to do everything, then I'll be horizontal. I don't go deep into it. Then I don't have the advantage of benefiting the court with all the jurisprudence on a certain aspect. Remember, on even Section 83 itself, you could write books and books and books. Now you need someone to get the expertise on that, and also probably the AG to get an expertise on something else. And how I wished that the amicus was much more, but on specific issues. So the court doesn't have to delve much into the research. It is
but the question is, just briefly in 30 seconds on that, does it stop these other parties from submitting on Section 83 and obviously from touching on minor curiae, IABC versus minor curiae?
In fact, the more reason why they should be very observant on that issue, because this is the narrative by LSK, if taken by the judges, may direct them to a certain position. They must therefore, as much as possible, look at what has been said, and as much as possible, and effectually counter it if they think that opinion is negative or negates their submissions.
All right, gentlemen, in a minute, because that is done, in a minute each, as we close, and I'll start with Duncan. I know you want to say something else. Talk to us about the time allocation. Reduce 5 hours for the petitioners, the respondents, the first and second, 1 hour 30, 1 hour 30, and then to the third respondent, 3 hours, and 20 minutes for the interested parties and the friends of the court.
Generally, Ken, you'll see that the time limits that have been given are not exactly the time limits that were requested yesterday. And what informs this is the constraints of time, which we have indicated time and again, that even after this petition, Kenyans must sit down and relook at this particular issue so that we assure that we have enough time that will not curtail substantive justice.
Okay.
And as I'm talking about substantive justice, it's important for Kenyans to know that today is the 7th promulgation birthday of our Constitution. And it is very, very key that this particular court, in its decision today, has actually given a birthday to Article 159, whereby it has moved away from the position that the Supreme Court took in 2013 and has actually said that now we will not give undue regard to technicality as opposed to substantive justice.
All right. Just in 30 seconds, I have to let you guys go on time.
One, we are looking forward to seeing this decision coming out. You know, there's a balance between quality and quantity. You know that the judges are being faced with a lot of volumes in terms of what they have to read within limited period of time. And then they are trying to understand that 2013 they were criticized so much for the judgment that people thought was not of high quality.
Okay.
And the Supreme Court is designed to come up with very interesting jurisprudence.
Okay.
So I think this petition will provide an opportunity for the Supreme Court to come up with very reasoned judgment within the limited period of time, and therefore there has to be a balance between quality and quantity.
All right. In closing.
I think the magnitude of the decision that will be made by the Supreme Court is what we are expecting in this country. We want to see value addition to jurisprudence. We want to see analysis that will guide the country for the rest of the time. And more so, now that they have given a glimpse of hope that Article 159 2D is now being given more gravitas.
Okay.
It gives us an opportunity to litigate without fear of being knocked out on technicalities.
All right, George, finally.
Well, one of the questions you get when you join a law class is, what is law? And there are many, many responses to that, and many people who've written on that, many scholars. But one is, law is what the judges say it is. And I think in this instance, we'll have to conform to that. We'll wait for the judges, because they'll say what the law is.
All right.
Thank you.
Thank you, gentlemen. Kakai Kissinger, Duncan Okatch, Moses Kurgat, and George Kithi for coming and sharing with us. And obviously, the case begins proper tomorrow at 9 a.m. Make a date with the NTV. We'll be there, and we'll be here with our panel. And of course, thank you for watching right from Supreme Court of Kenya. Decision 2017 continues